Good morning, everyone. And hello and welcome to our Employment Law Forum, where we break down the latest developments in employment law and what they mean to you and your business. In this third episode, we're diving into the new rights and responsibilities employers need to be aware of, especially in light of the recent labour initiatives, and covering topics on strengthened safeguards for employees experiencing menopause, enhanced protection for employees with neurodiversity, and other key updates regarding the progress of the Employment Rights Bill. As with previous forums, we encourage you to ask as many questions and share your thoughts on our Q&A feature. And please be rest assured that your names will remain confidential. Donal, for those of our audience who haven't attended previous forums, could you start by telling us a little bit about yourself?
Certainly. Morning, Julia. Hi, everyone. I'm Donal Moon. I'm an employment law advisor with Moore Kingston Smith HR Consultancy. I've been working in employment law for about 17 years, and the last 12 of those have been spent here. So my role is all about helping clients navigate complexities of employment law, and I work closely with our HR consultants here to provide well-rounded support to clients. I'm really passionate about ensuring our clients are informed and protected in the employment law space.
Thanks, Donal. So what inspired this particular forum?
Yeah, so we were getting a lot of inquiries from clients about the proposed changes to employment law. A lot of people very concerned about it. And whilst we've been running general update sessions, I felt it would be useful to break things down into more digestible discussions. So really giving people a chance to ask questions and really understand the implications and topics.
Right, so let's start by the big one. How's the Employment Rights Bill progressing?
Yeah, so the bill is progressing very rapidly. It's now passed through the House of Commons and it's being considered in the House of Lords. The next reading is in July 2025. And so once that happens, it then comes back to the Commons for further review.
And what are the key updates since our last forum?
Yeah, so quite a bit to cover there. So in March 2025, the government responded to several employment law consultations that were going on out there, and those feed directly back into this bill by way of amendments. So I'll just go through, if that's okay, some of the highlights. So there'll be a new Fair Work Authority created to enforce rights around minimum wage, holiday pay, SSP, and agency worker protections, and also covering regulating umbrella companies. Agency workers will be entitled to guaranteed hours if they work regular patterns over 12 weeks. And what that does is to close a potential loophole that would have allowed employers to use agency workers to get around the requirement to offer more stable contracts to workers. Umbrella companies, there's a bit of a development there as well. So the government's introducing major reforms to regulate umbrella companies, and the aim is to improve worker protections and tax compliance at the same time. I'm not a tax expert, so I can't give detailed overview of the tax provisions, but I can summarize it briefly so employers are aware of it. So what the updated Employment Rights Bill is going to do with umbrella companies is that it's going to legally define them as employment businesses, bringing them under formal regulation and making sure that workers have clearer rights. So, for example, holiday pay, sick leave, et cetera, et cetera. So rights that you would associate with any other worker. And from April 2026, responsibility for PAYE and national insurance will shift to recruitment agencies or end clients, and that will reduce tax avoidance and increase accountability from umbrella companies. And interestingly, the reforms also include a requirement for more stable contracts, meaning umbrella workers must be offered a guaranteed minimum hours. And that marks a significant step away from what we've got at the moment. So insecure 0 hours arrangements towards more predictable fair employment.
Excellent. And you mentioned SSP in that.
Yes, I did. So SSP, just to recap something that we discussed on the last forum, the 3-day work waiting period will be abolished. meaning that statutory sick pay will be available from day one of a period of sickness rather than employees having to wait for 3 days and then being entitled. And the lower earnings limit is being abolished. And on the last forum, we said that we were awaiting confirmation of what the rate of sick pay would be for workers earning below that threshold. We now know that it will be 80% of pay.
Interesting. And redundancy protections?
Yes, so redundancy protections being strengthened also for pregnant employees and those returning from family leave. So essentially, what's happening is those employees are going to be protected for a period of 6 months from the end of their leave. And what that means in practical terms is that they must be offered any suitable alternative in a redundancy situation, in preference over any other candidate, even if the employer takes the view that someone else might be better suited to the role. And the last point to note, just because I know this often causes confusion with clients, is that when you're looking at suitable alternatives, it's not enough to offer an opportunity to apply. It must be an offer of the actual role.
Okay, and we've just received another question from our audience. How should employers prepare for the Fair Work Authority's enforcement powers, especially if they use an umbrella company?
Yes, that's a really good question. Uh, so employers really can do a number of things to get ahead of the game. So I think reviewing supply chains would make sense to do, conducting due diligence on umbrella companies that you work with, um, making sure that your house is in order with all of the other potential legal issues, checking for compliance with licensing and pay standards for umbrella companies. The issue with umbrella companies specifically is that if the umbrella company is non-compliant, then the employer could be, or when I say the employer, I mean the end user, could be held jointly liable. So yeah, definitely worth getting your house in order as much as is possible before, and don't wait till the last minute to try and do that. Also wise to document all of the checks and ensuring that you're making and ensuring that your contracts with umbrella companies reflect these responsibilities. For example, one thing that I've seen employers do in the past is to include warranties in commercial contracts and specific terms, confirming to you that they comply with all the relevant provisions before you'll sign up to the contract with them. I think that can be quite helpful.
Understood. We've got another question from our audience, so they're coming quite thick and thin here. Here we go. Maternity protection period is 6 months from the date the employee is back from work. Is that correct?
Yes, that's right. So it's 6 months from the date back to work. That's absolutely correct.
And then another question, redundancy during maternity protection period, does it mean that we have to unconditionally offer the role to the protected employee?
Yes, it does, and that goes back to what I was saying a moment ago. Some people think they can get away with offering the opportunity to apply. That's not good. That's not sufficient to satisfy the legal requirement. You have to actually offer the role. And again, that applies even if you think actually we've got someone that we think would be better suited to the role. Doesn't matter. The obligation is to offer that suitable alternative to them.
Okay, another question. Here we go. Will the new redundancy protections apply to fixed term contracts or only permanent roles?
Yeah, so these protections are going to apply broadly, and that will include to fixed-term employees, so provided that they meet the qualifying criteria, of course. But employers should ensure that all redundancy protection processes are fair, transparent, and that returning parents are given priority for the suitable alternative roles. I think I've covered that in a few sort of
Mm.
questions, but it's worth labouring the point again because it's quite an important one, I think.
Okay, I think you've covered this, but what about selection criteria? And if it doesn't match, it creates unfairness to other employees. So, as you just
Yeah,
said,
no,
treat everybody equally here.
that's yeah. I mean that's an argument that I've heard several times before, but unfortunately, it doesn't matter once there's a suitable alternative employment vacancy available in a redundancy situation where someone on maternity or family leave is involved. You have a legal duty to offer that role to the employee. It doesn't matter about whether you think someone would be more suited to the role.
100%. So there's a lot of change happening. Is there anything that hasn't made it through to the bill?
Actually, yes. And before I do that, I just remembered that there's two other changes coming in as part of the Employment
Oh,
Rights Bill that I didn't mention. One is the tribunal time limits. Last time we did the forum, we were waiting for confirmation of what those were. We now know that they've increased to 6 months from 3. And trade, there'll be a few changes made around trade unions. That probably requires a forum all to itself, I think, because it's quite complex. But ultimately, some of the anti-union legislation is being tweaked and amended to make it easier for unions to be recognised. So that's to recognise and represent staff. I think that's in broad terms what's happening. But yeah, perhaps something for a future forum once we know a bit more, I think. But yeah, no, there are a couple of things that didn't make it into the bill. Some proposals have actually been dropped for now, which is quite interesting. So, for example, the right to disconnect, that was causing a lot of interest and understandably a lot of concern with clients about how it would work and how it would affect their businesses. We first thought that it was going to be legislation. It was announced to great fanfare by when Labour were seeking election. It then got downgraded a little bit to a code of practice, and now it's been abandoned altogether. And the merger of employee and worker status, which would have opened up a load of employment rights to workers as well as employees, hasn't progressed at this time. I think what we can say is that these have been abandoned for now. Right to disconnect certainly gaining global traction. So I would be surprised if it doesn't come back in some form or another at some point. Whether that happens within this term of this government, I can't say. But for now, we just know it's been abandoned. And again, merger of an employee and worker status, I think that probably proved to be a little more complex than the government thought it would be. So it's probably going to be a longer term review. But again, I may end up eating my words because everything's progressing quite rapidly at the moment.
100%. Another question from the audience. If there is a site that's sold, so acquisitions and mergers, does it affect the pregnancy stroke family leave protection?
Sorry, if there are,
If a site is sold, so I assume
yeah,
the company's going through an acquisition or a merger, does
yep.
it affect the pregnancy or family leave protection?
No, rights and liabilities transfer to a new employer, generally speaking. So no, it wouldn't. I don't think it would affect anything. I suppose you'd have to look at firstly whether 2P applies to the transaction. If it does, then rights and liabilities would transfer. If not, then that may bring you into a different situation. But that's quite a complex one which I think would probably be better taken offline, just because there may be a few nuances to that query. But generally speaking, no, I don't think it would. You may well be looking at a situation where TUPE applies and therefore rights and liabilities transfer across to the new employer. But if not, that could create a few interesting nuances, I think, that may require further discussion.
Now we're talking about timelines and what to expect. So another question from the audience: could these changes come into effect earlier than expected?
Some of them certainly could. It's quite possible.
Mhm.
Things are moving rapidly. I looked at a list of all of the readings that the bill has gone through, and there are lots of them for something that was introduced not that long ago, to be fair. So here's what we know so far, and bear in mind, I don't necessarily like to engage in crystal ball gazing. So what I did was I've looked at various commentators and what they're saying on the matter. So here's what I know. The ban on fire and rehire, people are saying, could come in as early as October 2026. In addition, the change to the Equality Act to and in particular the duty to prevent sexual harassment, making it a duty to take all reasonable steps, could come in this year. That's kind of stroke of the pen sort of change, so it could come in quite early. And the reintroduction of the third party harassment provisions might be expected this year.
Thank you.
Changes to 0 hours contracts, statutory sick pay and tribunal time limits. It's thought could take effect from April 2026. So that's no surprise there. Everything was expected around 2026 anyway. But unfair dismissal reforms, there's no signs of any changes there. That's still not expected in before before autumn 2026, and that's because I think the government realizes that companies will need time to prepare for this quite important piece of change. And the Fair Work Authority that I mentioned earlier, which will be the body that's in charge of enforcing everything and regulating umbrella companies, no confirmed timescale for that yet. So it's one of those watch this space moments where we'll keep an eye on developments and see what happens. But again, overall, we'll continue monitoring developments and keep everyone updated. Because, as I say, the bill is progressing rapidly, so things can change. There's a lot of moving parts involved, but yeah, in general, that's what people are saying. Whether that turns out to be the case or whether it all comes in 2026, I couldn't say. But yeah, you're right. It is possible that things could come in quicker than we thought.
Okay, we're going to go on to the topic of menopause. So what's the legal responsibility here?
Yeah, so okay, menopause is an extremely interesting topic. So it at the moment, it's not a protected characteristic under the Equality Act 2010. But employees experiencing menopause may be already protected under existing characteristics, such as age, sex, or if symptoms are severe enough, possibly disability. Employers therefore need to ensure that they don't directly or indirectly discriminate and should make reasonable adjustments to support staff who are experiencing the menopause.
So I believe you've already covered this, but when symptoms are severe enough, a question from the audience is it considered a disability? Is there any chance menopause will eventually become a protected characteristic?
Yeah, it's quite an interesting.
In its
That
own
is an
right,
interesting.
its own
Yeah,
right.
that is an interesting. Yeah, I think I get where that question's coming from. So yeah, certainly very interesting one. Unlikely at this stage, I think. The previous government ruled this out because I think, as I mentioned a few moments ago, it's already covered by 3 existing protected characteristics, possibly. Labour generally has been supportive of additional protections, but they haven't committed to legislative change to make it a protected characteristics. That could change, but at the moment they haven't committed to anything. What they're doing instead is is requiring large employers to publish menopause action plans and issuing guidance to smaller ones, similar in approach to gender pay gap reporting and equality action plans.
Okay. I'm going to go back to our previous topic regarding maternity, because it seems to be a very important topic for our audience. ACAS says the maternity protection period is 18 months from the date the baby is born, but just now you mentioned it is 6 months from the date of the parent returning from maternity leave.
Yeah.
Which one do we apply for now?
That's a really good question. So no, I think the protected period. Yeah, I think apply the ACAS one for now.
Yeah.
And once this law comes in, then apply that new one when it comes into force. Yeah, you have to apply. Yeah, I appreciate there are some things you can prepare for in advance, but you must apply the law as it stands now. So you use the ACAS guidance for now, and when this new law comes in, then apply that one.
Going back to menopause, sorry. It sounds like a very positive step. What should employers include in their action plans?
Yeah, so that's a good question also. So it's good to see people engaged, by the way. We're getting lots of questions on various topics here. So yeah, so there's a number of things that you can include in action plans. So support measures would be the most obvious one. So for example, flexible working, it could be uniform or workplace adjustments, and then how menopause related leave is tracked if that's done. To help provide identify potential support areas. Even though it's not law yet, I think employers can start getting ahead of the game now. I know I've said getting ahead of the game a few times, but I think that's fundamental in the context of all these changes. They could start reviewing policies. They could start consulting staff and engaging with staff to help formulate policy. Because let's face it, policies are best when you engage with staff and get their input into it. And training managers. I think is fundamental to deal with these issues, so that you don't end up in legal hot water and someone doesn't go rogue just because they don't understand what the law is and how they should be supporting people. Also, a number of wellbeing initiatives that you could undertake, and then perhaps partnering with subject matter experts or getting them to come in and help train you or help you understand the requirements, and possibly even reach out to your EAP provider. So I understand a number of them can provide really useful information and partner up with you to help. I just think, yes, whilst there's no obligation obviously to move before a law comes into place, to my mind, I think early action shows commitment and helps improve engagement and retention.
Now, I believe it applies to sort of larger employees, but how does it apply to smaller organizations and businesses?
Yeah, thank you, Julia. So yeah, larger employers, just to define what that means, larger employers in this context is 200 text is 250 people or more. For smaller employers, so less than that amount, Labour plans to issue tailored guidance. So they're not it's kind of more a carrot than a stick approach, but guidance that smaller employers should live with. But as we all know, with guidance, it will probably come in the form of an ACAS code, which means if you don't comply with it, then there's a possibility of compensation uplifts. We'll have to wait and see how they do it, but that's how I suspect they'll tackle the issue. But in the meantime, I still think employers can take simple steps, even smaller ones. So management training that we mentioned, so engagement with staff, introducing flexible schedules and open communication. I think these actions tend to be fairly low cost, but they can still make a big difference.
Mm. And menopause is quite close to my heart. Okay, and I know we have discussed it at length on previous things that we've done together, and namely the article that we wrote. And I think that a really good initiative that some companies could look to do, and this is not a sales pitch, it's just something that's out there, is pledge and sign up to menopause. So consider Menopause Workplace Pledge. I think it comes from a company called wellbeingofwomen.org.uk, and it encourages organisations and companies to raise awareness, really understand their staff, train them. It creates a lot of opportunity for an inclusive environment, and I think knowledge is absolute key. And they've got a lot of information on that particular website. So Donald, again, your thoughts? I think we've covered it, but over to you.
I remember us discussing that. I think that was a really useful website. I think anything like this that gets, I suppose, as an employer, anything like this that gives you further information. And when I looked at it, it's an amazing website. It's got toolkits, it's got guidance, it's got pretty much everything you could think of that you would need. But in addition, there's a pledge that you can sign, and that really, to me, I'm not saying employers have to do it, but there's a few big name brands that have, and I just think it really shows people that you're kind of prepared to take action to support staff who are experiencing menopause, and not just that. I think by signing the pledge, you're almost committed. You're almost pushing yourself to do more, because once you've signed it, you have to kind of walk the walk instead of just talking the talk. So I think I just think that was a really good website. I would encourage everyone to visit it. I think we've. Do we need a link or anything for it, or for perhaps people find it useful?
Sending a link through. We'll send a link through
Excellent.
in
Okay.
our comment section to our audience if
Yeah,
anyone's interested.
I think that'd be really good.
But there is another question. Here we go. And it's actually from an HR manager. There you go. If menopause isn't a protected characteristic, how can we ensure our policies are still legally sound?
Yes. So a good point. Again, your policies can still be as legally sound as they can be in relation to the three potential characteristics that menopause is covered by. Because yeah, whilst it's not a standalone protected characteristics, it may still fall under disability, sex, or age discrimination. So policy should already really be reflecting those things. But in terms of the new duties, I think insurer managers are trained to handle issues like that sensitively, and that adjustments are made where needed. And I think a clear supportive policy can go a long way in reducing risk and improving employee well-being. But yeah, so I would say just make sure that your policies reflect the law as it currently stands, because really, if it does, then you should be compliant. And then just wait for guidance, review the guidance, review your policies against that guidance, and update your policies accordingly, and then update training. But again, engaging with staff can be a really major step in that direction as well, making sure that it's
100%.
as supportive as you can be.
100%. Let's move on to neurodiversity. What are Labour's commitments here?
Yeah, so Labour has planned to raise awareness, and future guidance is expected. So employers, now again, I think this is another area where employers can start sort of forging ahead with these things, but starting to align themselves with best practice. And a good example of this, I think, is those in the CIPD's 2024 Neuro Inclusion Framework. And that covers things like inclusive recruitment, sensory-friendly spaces, tailored adjustments, so a whole host of things. But I think so that definitely is worth a review for employers. I would say that's another piece of essential reading, I think.
So what sort of practical and operational steps can companies take now?
Yeah, so again, so I would say audit current practices. Are they supportive of people with neurodiversity? Audit things like job descriptions, interviews and performance reviews, processes. So you could do things like introducing quiet zones, look at scope to introduce flexible work, and ensuring that communication is clear. Another thing that employers could do is potentially partner with neurodiversity consultants. And again, I think this is one where EAP providers might be able to help you as well. Again, I don't think these initiatives would be particularly high cost, but they would boost inclusivity and talent retention. And again, I think you can then adapt to any guidance that's issued as it comes.
Totally agree with you, Donald. Thank you. We've got another question from our audience. We don't have an HR department. How can we practically support neurodiversity for our employees?
Yeah, no, I completely understand. I don't think you need an HR team to make a difference. I think you can start with really small and meaningful changes, and then work your way up. So, like I mentioned, offering flexible working hours if you can, providing quiet workspaces and clear, structured communication, I think are all things that are perhaps don't cost the earth, but can make a massive difference. Also, free resources and charities that offer guidance and training, which I think are well worth taking advantage of. And again, there are neurodiversity experts that can help you. And really, it's all about creating an environment where people feel safe and supported. And I know I kind of talk about compliance a lot because I'm a lawyer. It kind of goes with the trade, but I think ultimately it is about doing the right thing and creating an environment where everyone feels safe and supported. And not just that, they're able to feel that they can contribute the most, which is ultimately what you want as a business, I think.
Great. We're on to the legal landscape and equality duties, but we've received another question from our audience. There's been a lot of talk about the Supreme Court's decision on biological sex. What does it mean for employers?
Oh, that is quite an interesting one, because it's kind of off topic for today, but nevertheless a really important issue. So just to give people a bit of a summary, so the UK Supreme Court's for Women Scotland ruling clarified that Sex and the Equality Act refers to biological sex, not gender identity, and that's even for those people with a gender recognition certificate. Yep, protections for trans individuals under gender reassignment still remain, but this ruling could have a number of implications for employers. But the key one that I keep reading about over and over again is single sex facilities and how those are managed.
Mm.
Um, Nothing in this ruling says that employers can't have gender neutral facilities. What it says is that they have to be in addition to, not a replacement for, single sex facilities. So removing single sex spaces could therefore risk indirect sex discrimination claims. So that's the position we've got to with that. But there's nothing to say that you can't have gender neutral facilities available. And in fact, I would say that as an employer, just ensure that you're doing the right thing to protect all individuals. So taking everybody into account. Interestingly enough, so in April, the EHRC, so the Equality and Human Rights Commission, issued an interim update about this judgment. And they noted that the legal obligations vary by context, which is not massively helpful, but it does show that you have to take into each individual workplace and work out what's reasonable, perhaps. But there's been a public consultation in May, and updated guidance and a revised code of practice is expected actually by the end of this month. So that's not too far away at all. So hopefully, I appreciate I've only given a whistle stop of this. There's probably going to be much more impact than what I've just mentioned. But I think it's just helpful to have that summary because I know that's the bit that a lot of people are pretty concerned about. But I think once we get that guidance, again, that might be a topic for a future forum because I suspect there'll be a lot to unpack.
Yeah, totally agree. In the run up to this forum, you and I were discussing the disability and workplace adjustments and what companies could do. But what's happening here?
Yeah, so the government, yeah, so no, thanks, Julia. So the government's consulting on changing the access to work scheme.
Mm.
So that's a really useful scheme for sort of helping make adjustments in the workplace and discovering the art of the possible for employers. Helpful for employees too, obviously. But what's being proposed is to streamline the application process and expand the support available. So that's really good. I think that's really good news for employers because it means that they'll have more help potentially in making reasonable adjustments than they had previously. Hopefully, if it all pans out the way we hope. But in the meantime, employers should review how they handle reasonable adjustment requests and train managers accordingly. But certainly make them aware of the access to work scheme. A lot of employers aren't aware that it's available. So I think it's useful for them to know about that.
Okay. We're on to equality duties and public sector implications. So what is the socio-economic duty under the Equality Act and why is it relevant now?
Yeah, Section 1 of the Equality Act requires public bodies to consider how decisions reduce socio-economic inequalities. The previous government, I think, had put a block on it being implemented for a number of years. Labour now plans to activate this duty. So it means the upshot of it is that public sector teams need to start integrating socio-economic impact assessments into their processes.
Okay. And so how does the public sector equality duty, PSED, apply to non-public bodies?
Yeah, yeah, that's a really good question. So a lot of people thinking, "Oh, why is that relevant to me?" Well, actually, if you're a private entity that's performing public functions, um, you're also covered. So if you're working with the public sector, for example, you will need to embed equality considerations based on socio-economic grounds into things like procurement, service delivery, decision making, and things like that.
Okay, so that's another question from our audience. What's the risk if we don't comply with the public sector equality duty as a private contractor?
Yeah, so if you're delivering public services, you're expected to meet the same equality standards as public bodies do. So if you're non-compliant, it can lead to reputational damage, contract loss, or even potentially in the worst case scenario. And this is the bit, right, I suppose, which should concern is legal action. Um, so yeah, if this duty is being activated, there will no doubt be a claim that can be pursued possibly even by the new Fair Work Agency once established. But it's important to embed equality considerations, I think, into decision making And more importantly, keep records of how you're meeting the duties, what your considerations are, so that they can be used as evidence if anyone says that you're not meeting this duty.
Donal, thank you so much for walking us through this. There's a lot for employers and businesses to think about, and your insights, I believe, have made it a lot clearer for everybody. And thank you for our audience for joining us today. Just before you all go, we're pretty much up to speed with the current labour landscape, but we want to hear from you as we plan our next forum, which will be our fourth one, probably in Q3, Q4, yeah. We'd love to know what the hot topics are that are on your radar. Are there any specific challenges that you're facing, or legal grey areas that you'd like clarified, or trends that you think we should explore? Drop us a message or email us directly, and your inputs help us shape the conversation and ensures that we're tackling the issues that matter to you the most. Donal, there's one more thing from yourself, I believe you'd
Yeah,
like to
yeah,
share.
just a small announcement really, that I thought I'd like to share with people. So I'm really pleased to share that MKS has recently merged with a well-regarded West End law firm. That exciting development means that in future sessions we may well be joined by other colleagues from more SGD law, and I think that will really help bring additional insight and depth to our employment law update. So I just wanted to share that just before we go today.
Well, thank you again, everyone. Have a great day. From Donal and myself, bye-bye.